The Minnesota Workers' Compensation Statute offers essentially 4 types of benefits. Well, let's go with 5. And I say to clients often, there are 5 buckets of benefits. That's an easy way to keep them separated in your mind. The first is medical. So all medical care and treatment that's substantially caused by the injury and that is reasonable and necessary to cure and relieve the injury should be covered by the workers' compensation insurer. You can tell a lawyer had something to do with the drafting of the statute. That's true because the legislature is made up of lots of lawyers. So basically that means that your injury is a big deal or a significant factor in the diagnosis, and that the treatment that is being recommended is appropriate. So that's the first category of benefits, medical treatment. That is good for as long as you can prove those 2 items, causally related to the injury and reasonable and necessary. The second category of benefits or buckets is called vocational rehabilitation. And by vocational rehabilitation, I don't mean occupational therapy or physical therapy. Rather, this benefit is embodied by a person, and that person is called a qualified rehabilitation consultant, or what we say in the industry, we call them QRCs, because that's much less of a mouthful, easier to spit out and say QRC. QRC is a person. I often tell clients a QRC is not a lawyer, not a doctor, not a claims representative, they're not a therapist, they're a vocational person, and they wear 2 hats. The first hat is to do what's called medical management. So they would keep the parties informed about what's going on in terms of medical care and treatment. They're also a liaison, almost a conduit. They'll get those medical records and they'll get them to the parties, keep the insurer informed, keep the employer informed, keep the attorneys informed, keep the injured worker informed, and they're very helpful that way. I tell my clients that having a good QRC on the file is like having a third arm, or a good QRC is worth their weight in gold. The second hat that a QRC wears is what is called the vocational hat. This is what you think of more traditionally when you think of vocational rehabilitation. This is where the QRC comes alongside the injured worker and assists with return to work elements. That could be working with the date of injury employer to see if that employer can accommodate the restrictions that have been assigned by the treating physicians. A QRC might go and do an on-site job analysis to evaluate a job and see whether it's physically appropriate for the injured worker given her restrictions. If a person loses a job, say the employer cannot or will not accommodate restrictions following a work injury, then the QRC can assist that injured worker with job search. And then the final piece of vocational rehabilitation is what we call retraining. Retraining is formal schooling that can last up to 3 years in length, and the goal is to give the injured worker a new skill set, a new degree, an ability to overcome the reduction in their earning capacity brought about as a result of the work injury. And retraining can last up to 3 years in length. That's 156 weeks. If you are in an approved retraining plan established by your QRC, then the workers' compensation insurer needs to pay you wage loss, needs to pay tuition, needs to pay mileage, needs to pay books, and if appropriate, needs to pay for custodial daycare. So that can be a hefty price tag for the insurer. So when it comes to working with a QRC, you want to make sure that you're working with one who is kind, all right, competent and trustworthy. You want all 3. You don't want to bat 2 out of 2, because the reality is that with QRCs, they are supposed to be neutral. They are created by the statute. They're a benefit even though they're a person. Work comp pays for them, and they're the best ones. I was told years ago, David, the best QRCs maintain the appearance of neutrality, and that's true, no matter which way they lean, because in their heart of hearts, everybody leans one way or the other. They tend to lean towards the injured worker, or they tend to lean towards the insurer. And oftentimes you don't know which way they lean until the wind begins to blow really hard. And then you see, I see where your bread gets buttered. So it's really important that as you work with a QRC, that you are working with somebody who is kind, somebody who is competent, and ultimately somebody who is trustworthy. You want all 3 of those. Don't settle for 2 out of 2, because as an injured worker, you have the absolute right to choose the QRC that you want to work with. And that's a very important choice. Third category of benefits is wage loss. So this third bucket would be wage loss. And the idea here is there are 3 subsets of wage loss. The first is permanent total disability. That is where you are so injured you are never going to work again in any significant capacity. We call that permanent total disability. And depending upon your date of injury, there might be a cap on how long it will pay. For injuries that happened after October 1 of 2018, it will pay up to age 72. There will be coordination if you receive Social Security disability. You won't get 100% of work comp, permanent total disability, and Social Security disability. There's a formula for how you apply an offset. Second category of wage loss is what we call temporary total disability. And this is where you are off of work for less than forever. All right. And temporary total disability can pay for up to 130 weeks. That's 130 weeks. That's 2.5 years if you do the math, but most people don't get 2.5 years. It usually ends sooner. It ends if you go back to work. Temporary total disability ends if you are released without restrictions. It ends if you make a full recovery. It also ends 90 days after you attain what is known as maximum medical improvement. But the idea is you're off of work, and either a doctor writes a note that says Susie should not work due to her work injury, or the doctor writes Susie a set of restrictions, which Susie gives to work, and work goes, gee whiz, Susie, these don't work, come back when you can do something. That would give rise to eligibility for temporary total disability. The final wage loss category in this third bucket is called temporary partial disability. This is where you've gone back to work and you are making less than your date of injury wage. And example, you used to make $1,200 a week when you got hurt, you had an injury, you are allowed to go back to work, but now you've got restrictions in place and your employer can only accommodate, say, on a part-time basis. So instead of making your $1,200 a week, you're now making $600 a week. Well, work comp would pay you 2/3 of that difference for up to 275 weeks as long as you have physical restrictions. In order for wage loss benefits to pay, you must have physical restrictions in place. That's the general rule. Of course, there are always exceptions, but 95% of the time you need to have a doctor who writes a note that says, Susie needs to work under restrictions, whether it's a 50-pound lift limit or avoidance of bending, twisting, things like that. It's restrictions that give rise to wage loss where appropriate. Fourth category of benefits is called permanent partial disability. The workers' compensation system does not have money for pain and suffering. It does not exist. So take everything you know about a personal injury claim, that is getting run over by a drunk driver or slipping and falling at a grocery store because somebody didn't mop up the floor, and things like pain and suffering and emotional distress, they don't exist in the work comp system. Instead, we have a benefit called permanent partial disability that is meant to compensate people for the permanent aspect of their injury. How that works then is there is a schedule that lists almost every body part. It's remarkably comprehensive. There are a few that are left out, and then it lists what's wrong with the body parts. And a doctor essentially takes that list of ratings when an injured worker has reached maximum medical improvement, that is, they've gotten as good as they're going to get. The doctor might perform a physical exam, or if somebody had a knee surgery, then it's going to be real simple to follow the schedule and come up with the appropriate rating. Ratings are stated in terms of whole body impairment. Now, for example, a standard knee replacement is worth 15% whole body impairment. And what's interesting about permanent partial disability ratings, and perhaps counterintuitive, is they have nothing to do with your restrictions. It's purely based on what's wrong with you functionally from the physician's standpoint as based on these rules. Final category are death benefits. And these apply only to a small subset of the dependents of an injured worker. So if an injured worker either dies as a result of the work injury or is killed because of the work injury, then death benefits, or what we more typically call them dependency benefits, can be payable. They can be payable to a dependent spouse or to dependent children. And if the dependent children are minors, then there's a different statutory formula that comes into play. There can be an offset for Social Security survivors benefits. But that idea in the dependency benefit setting, or what we call death benefits, is here's a benefit that's set aside for the survivors of the injured worker who was killed. There's also a burial expense reimbursement. It covers up to about $16,000 of funeral expenses if those can be properly documented. So those are the 5 essential types of workers' compensation benefits available under the Minnesota law.